federal requirements for all non-U.S. citizens to register their presence in the United States with the U.S. government under long-standing U.S. law, the Alien Registration Act. This law is now being strictly enforced, and the enforcement is rooted in Section 7 of Executive Order 14159, protecting the American people against invasion, which was signed by President Trump on January 20th, 2025. Here's a simple way to understand this law. If you are in the United States and the government does not know you are here, then you need to register. Let's take a look at the people who must register. Number one, individuals who are 14 years old and above, who are non-citizens. These people were not fingerprinted or registered when they applied for a U.S. visa, and those people are planning to stay in the United States for 30 days or longer. They must register before the expiration of the 30-day period. Number two, children who are under 14 years old, their parents or legal guardians, they must register these children if they were not registered upon visa application and if they intend to remain in the United States for 30 days or more. They have to ensure that they register before the expiration of the 30-day period. Number three, previously registered children who are turning 14 years old. They must re-register and provide fingerprints within 30 days after their 14th birthday. There are some non-U.S. citizens who are not required to register because they are already registered. These people include number one, green card holders or lawful permanent residents. Number two, work permit holders. Number three, individuals in immigration court proceedings. Number four, visa holders like B2 visas, F visa holders. These people are already registered. The following people are not registered and should register: people who enter the U.S. without inspection. And number two, Canadians who entered the United States through a land port and were not issued a formal registration document. Number three, applicants for immigration benefits not listed in 8 CFR section 264.1a. These include DACA, Deferred Action for Childhood Arrivals, TPS, Temporary Protected Status. Now, here are the key requirements. You must register within 30 days of arriving in the United States. You must submit your fingerprints to USCIS, and then you will receive proof of registration from the DHS, and you have to carry your registration document on you at all times if you're 18 years old or older. Remember that this registration process does not confer any immigration benefits. It's just an enforcement tool. There are penalties for not complying with the two parts of this rule. There's the registration compliance, meaning you have to register to be in compliance, and number two, you have to carry your evidence. If you fail to carry your evidence, then there are penalties for that. And so the penalties for failing to register and failing to carry evidence include fines, imprisonment, or both. Should you register? Well, there are pros and cons. You can avoid civil and criminal penalties if you register. Cons: this may be used in enforcement proceedings later against you. And again, if you have a case pending or you intend to apply for an immigration benefit, then your failure to register could be used against you, specifically in cases where there's a discretionary analysis. Speak with a U.S. immigration attorney to find out how this affects you or your case if you do have an immigration case pending. Again, we've prepared this document we're sharing, and you can check out the document, look at the process, and give us a call if you need our help. 802-780-0564. Thank you for watching. I'll see you in our next video. Bye-bye.